we are here unified as 11 chief executives and heads of the nation's most influential civil rights organizations in the nation. And we want to take some time with you today to give you our perspective and our interpretation on the Supreme Court's decision issued earlier this morning on quote unquote the issue of affirmative action in higher education. I'll give a few opening remarks, and then what we are going to do is go to three of our colleagues who actually were involved in the actual litigation of the case, representing a variety of parties, because we think it's important to centralize what the court's decision is, because there's a risk here that the decision be misinterpreted. Now, I'll say this from my own perspective. This decision reeks of politics. It's a Trumpist decision by a Trumpist court. And while the decision narrows the use of race in higher education admissions, it does not outright ban it. Number two, from our perspective, this decision is a gutting and a weakening of years of progress towards racial justice in this nation via the very sacred 14th Amendment and its equal protection clause. And we condemn the trivialization of the long racial history of this nation and this interpretation of the 14th Amendment, because we believe it is incorrect. We think it is wrongly decided. We think it steps on years of precedent by a variety of courts over a series of years and seeks to gut this nation's long march from its history of racial exclusion, discrimination, and exploitation to a nation which is more racially just. It is important to note, and we will amplify this, what this decision does not do. It does not affect corporate diversity programs at all. It does not affect minority business opportunity programs at all. It is limited to admissions in higher education at selective admissions universities in the United States. So it's important, and we want to emphasize what this decision is as much as what it is not. And we will spend some time talking about what we think the path forward is. And before turning it over to the lawyers, we come to you today as leaders of historic civil rights organizations who've been in this work, in some cases for more than 100 years, in every case for more than 50 years, on the front lines in litigation, in protest, in legislation, in thought leadership, and in public policy. So we bring to this the long experience of being involved in these issues, which is why we think we have to speak in a unified fashion, speak very forcefully, and speak very unambiguously about this decision. We feel that the Supreme Court has undercut and turned its back on racial progress. Nonetheless, there's a window, there's a door, there's an opportunity here that allows us to maintain some semblance of pursuit of racial justice underneath the 14th Amendment. So having said that, I want to go to Janae Nelson, Damon Hewitt, and John Yang, colleagues who were involved in this litigation. And then after that, we'll go to Reverend Al Sharpton and then everyone else, and I will call everyone's name. So with that, Janae, let me turn it to you.
Thank you so much, Mark. And thank you all for joining us on this dismal day for our democracy and for our diversity, which is the biggest strength in our nation. My name is Janae Nelson, and I'm the President and Director Counsel of the Legal Defense Fund. I'm proud to represent LDF, and we've been involved in every case involving affirmative action that has gone to the Supreme Court ever. And this is the first time that we are facing a court that misinterpreted the Equal Protection Clause and our seminal case, Brown versus Board of Education, after a predecessor court made very clear what the principles were in the Constitution and in the Brown case in support of affirmative action. Today's case, to be very clear, does not end affirmative action, but it makes it much more difficult, and it narrows the ability of the higher ed institutions in our society to use their own discretion and their power to decide who should be in a classroom, who among the many qualified and talented students that our nation produces should have the opportunity to learn together and learn from one another in our most competitive institutions. So we take strong issue with how the court interpreted Brown, how it interpreted the Equal Protection Clause, and making it more difficult for us to do the important work to serve our multiracial, multi-ethnic democracy, a democracy that will be a majority people of color population in 20 years. We need to invest in that future leadership. We need to invest in education and opportunity, in the freedom to learn, and not narrow those opportunities. I agree with Mark that this was a decision that reflects politics. It reflects policymaking from the court. It does not reflect sound, impartial, objective, legal judgment. And we deserve more from our court. That said, we are not abandoning the fight. There are many opportunities that we will continue to fight for to ensure that students of all backgrounds and races, especially Black students, Brown students, Indigenous, Asian students, students from rural communities, students who don't have access, are still able to enjoy the excellent higher education system that we have in this country. And so I look forward to taking questions about the case and about the way forward.
Thank you very much, Janae. Damon?
Thank you so much, Mark and colleagues. Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Our organization was proud to represent students at Harvard and UNC, and students in particular at UNC as defendant interveners in the case, to put on witnesses and evidence at trial, to develop the strong record that was cited a number of times. Our clients were cited, their lived experience was cited by the dissent in today's case, and also for our attorney, David Hinojosa, to argue this case before the US Supreme Court in late October. Friends, today the Supreme Court got it wrong. And I do think this date will live in infamy because it is one of the most tortured decisions that I think any of us have really ever seen, because it seems to be twisted in terms of its logic on the law. It misreads history, and it fails to cognize current day facts, including the lived experience of not only students of color, but even of some of the justices themselves. It is a decision that is not grounded in our reality, which is a race-conscious reality. To be clear, while today's ruling is a setback, it is not the end of the road. Nothing will deprive us of what we call our race-conscious future. The court has even acknowledged this itself implicitly. The majority opinion indicates that nothing in the opinion stops universities from asking students about their race. Nothing in this opinion, Chief Justice Roberts wrote, should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so what that means is our advice to students is this: continue to talk about your identity and your experiences with race and racism. And to universities, double down on the opportunities for students to do that through the admissions process, on campus, with alumni, what have you. Make sure that your environments are not just generally welcoming environments through words, but also in deeds. It's also to be clear what this case did not do and what it's not about. The court did not overrule precedent outright. A lot of folks are saying that. We even see some of that in the dissent. But our reading at the Lawyers Committee is that the court did not explicitly overrule Bruder. It simply applied it in a very twisted way. The law continues to exist that we knew before this case, but applying it now becomes much more difficult. We have a lot of litigation ahead, a lot of roads ahead, and in many other cases, because it will be difficult, frankly, for colleges to figure out what to do. My advice is to take the opening that the court has given them and to move forward. Finally, what this case also is not about is about what some people are saying in media today about immediate implications for business, for employment law, and also for other contexts, even philanthropy. People are saying, well, we can't make those grants anymore, or we can't have DEI programs anymore. Make no mistake, they will attack those programs, but they've been attacking those programs anyway. The law, as it applies to employment discrimination, business context, DEI, ESG, philanthropy, the law has not changed. The law has gotten complicated for higher ed, but the law has not fundamentally changed in every context. Now is not the time to turn back or to retreat. Now is the time for every business, every higher ed institution, every nonprofit organization who made all these proclamations after George Floyd was murdered. Now is the time to stand together and to stand with us and to continue to fight for the future that our students deserve. Thank you.
Thank you very much, Damon. John Yang, are you with us?
I will be stepping in for John Yang. Thank you.
Go ahead.
Thank you. So thank you, Mark and the National Urban League for convening us. I am deeply grateful to be in solidarity with all of the leaders gathered here, with your organizations and the communities that you represent. My name is Maritza Cabañas, and I am Vice President for Strategic Initiatives with Asian Americans Advancing Justice, AAJC, and we were involved in representing student voices in the Harvard case. We are, of course, deeply disappointed that the Supreme Court came down today on the wrong side of protecting educational access and instead opted to resurrect barriers to higher education and support systemic racism. Now, Asian Americans Advancing Justice, AAJC, has long worked to advance racial equity and to protect race-conscious admissions. While today's ruling is a blow, we absolutely will not stop working to ensure equitable access to educational opportunities for Black, Latino, Native American, and marginalized Asian Americans despite today's ruling. Many people have already shared and will continue to share information about today's decision and what it means. I want to use my limited time here to address the Asian American stake in this matter. We have long known that the majority of Asian Americans favor affirmative action policies. In fact, 69% of Asian Americans support affirmative action in education. Many narratives lift up those who oppose affirmative action, but know that our community stands in support of affirmative action. Moreover, we know that our nation's future depends on people across races and ethnicities working together to achieve equity and diversity in higher education and ultimately a thriving multiracial democracy. Diversity helps everyone, including Asian Americans. It's important that we all keep in mind that talent is everywhere, and it is incumbent upon all of us to ensure that we create real pathways to unlock that talent in every student, no matter which community they come from. So we need more Asian Americans to join our movement to ensure that no student in a community of color is discriminated against or marginalized because of this ruling. Our public schools are besieged with inequities. We have to work together to improve our public schools, K through 12, so that all children have the same access to safe and quality education, resources, and learning opportunities. This means we have to double down and recommit to solidarity and supporting one another. So when school boards make efforts to improve access to educational opportunities for Black, Brown, and underserved Asian Americans, we have to support, not oppose those efforts. Asian Americans cannot erase history to fit a contrived divisive narrative of being the model minority. We cannot ask for our schools to teach Asian American history while suppressing the experiences of Black people. And we can't preach against anti-Asian violence while ignoring the real dangers faced by our LGBTQ and non-binary youth. So know that despite today's decision, we are not giving up. We are going to continue the fight with even more energy and even more conviction. So I hope that more people from our communities will join us to keep the doors of educational opportunity open for all.
Mark, you're on mute.
Thank you very much for those comments, Reverend Al Sharpton.
Thank you, Mark, and to all of my colleagues. Certainly there has been a lot of outrage at this decision by the Supreme Court, but I think few of us were surprised, given the nature of this court and the politics of this court. The decision had not been fully released before some of the political types like Donald Trump saluted the decision and reminded the world that he put 3 people on that court, which is a third of the court. There are 9 justices, a third of them was appointed by Donald Trump. So let's be clear of the political intent of this. I think that our colleagues that have fought gallantly and I think effectively to defend social justice, our legal rights, and our initiatives such as affirmative action have done a great job. And I think that they have educated us in terms of what the law says and does not say. Our fear in National Action Network is those that will misinterpret and misuse this, which is why all of us must be united in monitoring and enforcing the rights of people that will be denied. This ruling can be a dagger in the backs of Blacks and others if we allow them to distort this to say that you cannot talk about race, that corporations can distort it and their unfulfilled commitment after George Floyd and say, oh, we can't deal with race anymore. We must challenge that from DOJ all the way across the board to our own protests and activities. We are guided by some of the best legal minds in the country. You just heard them, certainly Janae Nelson and Damon and John Lang's representatives. But we are not going to depend on the goodwill and the good interpretation of those in the educational arena or the private sector that will not intentionally distort what happened today. Let's remember, affirmative action started under Republican Richard Nixon, authored by Arthur Fletcher. It was a conservative remedy to historic racism, systemic racism. And anyone that looks at the data will say that we still have systemic racism in this society. So the need for it has not gone away. And to use the 14th Amendment that came as a result of ending slavery against us that are still struggling after 246 years of chattel slavery, 100 more years of legal segregation. The reason that many of us had to catch up is not because our parents were inept, they legally were barred. There's nothing wrong with our genes. We're still almost doubly unemployed. We still are 10th of white wealth. Nothing wrong with our genes. It was something wrong with the laws. And until we can repair what was done to us, we cannot stop the things that will equalize the playing field. Why should government do it? Because government was the ones that made it legal. It was not Southern customs that we couldn't go to certain schools. It wasn't Southern customs that we sat in the back of the bus. It was the law. Rosa Parks wasn't sent to courtesy school. She was arrested. And we must deal with the law. And what they got done today is narrow this to where it is open to anyone's misinterpretation. And we will be the warriors to make sure they will not get away with that misinterpretation. And we will be there to protect the interests of those that may be victimized by a misreading of this law, and will challenge this as we have a stacked court that Mr. Trump and others are taking credit for today. So I stand with my colleagues, and I'm grateful that they've given us the letter of the law. We're going to be on the ground making sure it is properly enforced.
Thank you, Reverend. We appreciate those remarks. And Melanie Campbell. It's on you.
Thank you, Mark, and thank you, Reverend Al, and everyone, all my colleagues here today. I want to kind of echo where a little bit where Reverend Sharpton left off, because I do think it's very important that we understand that this attack on affirmative action is also, this ruling is another attack on our rights and freedoms in this country. The reality that we want to make sure that elections do matter. And we're not going to roll over. We have some of the brightest lawyers across all diversity when it comes to this on this call and others. And I know we're going to keep fighting in the courts. We're going to also fight at the ballot box as well. And so that's going to be important. It does matter who puts who on the Supreme Court. Believe that there is a very much a need for Supreme Court reform. We hear about that. It will be an issue in the election. And the court today, they not only got it wrong, and I'll speak from myself, I think it was very unethical what they did today. And that our children and our children's children will be impacted. What happened today may not be a full sweep against it, but it's also part of the continuous attacks on diversity and opportunity in this country. And the last time I checked, Black people, brown people, we pay public tax, we pay taxes. So what you're saying to the street person on the street is, well, you can keep paying taxes to help cover public education, for public colleges, but you can't make sure that your children are able to go to school and get the education of choice. And that for the average person, they get that. And so we're going to continue to fight. We're going to continue to confront it. We want our friends in corporate America to understand that, as Reverend said, do not use this as an excuse to go after diversity, equity, and inclusion. We want to make sure that they should be speaking up loud and clear that they're not going to do that. So we call on them to do that. And the last thing I think was really, really important to talk about diversity and a voice was what Supreme Court Justice Ketanji Brown Jackson said in her dissent. And I quote, she said, "Our country has never been colorblind because the majority's judgment stunts that progress without any basis in law, history, logic, or justice. And I dissent." And so we thank her for being there. We thank Justice Sotomayor, who was just powerful in what she had to say. It matters that there is diversity on that court, even if the opinions weren't done in the right way. And the history will judge that court and what they did or what they did not do to lift up this country for all its rich diversity. They're trying to set us back through so many means and so many other things. And so the election is in 2024. And I know that we will be paying attention to that. Our community will understand how they have an opportunity in 2024 to make sure that there are others who, when the other opportunities come, because last I checked, the president is the one who nominates who sits on that Supreme Court. And also a Congress that can do some remedies as well. So we're gonna keep fighting. We're not gonna go idly by and quiet in the night. We're not gonna allow ourselves to be wiped off the map as if we don't exist. We exist. We help build this country, and we will continue to fight until we have opportunity again for our children to have more rights than we did. So thank you, Mark.
Thank you, Melanie, and we'll now go to Janet McGee.
Thank you, Mark. My name is Janet Murguia, President and CEO of Unidos US, the largest Latino civil rights and advocacy organization in the country, previously known as the National Council of La Raza. I'm really honored to join with our partners and colleagues in the civil rights movement to express our deep disappointment with the short-sighted and terrible decision by the Supreme Court. Sadly, the Supreme Court's decision today has made the playing field a lot less level and moved the starting line even further back for students of color. It strongly concerns us that the majority of the US Supreme Court fails to see the importance of diversity in higher education to our nation and its future. As a former executive vice chancellor for my alma mater, the University of Kansas, I saw firsthand how essential access to higher education is to students and how much a vibrant and diverse student body contributes to the education of every student and to higher education overall. And from a Latino perspective, we cannot and must not repeat the mistakes of the past. We saw what happened in California in the aftermath of Proposition 209 that barred race-conscious remedies in the UC system. It has been a generation since that proposition was enacted, and despite the fact that more than half of young people in the state are Hispanic, they continue to be severely underrepresented at California's major colleges and universities. That is what is at risk with today's Supreme Court decision. Higher education is the gateway to economic achievement and the training ground for our nation's future leaders. We are shortchanging not only our communities, but our country by failing to ensure access to higher education for all, and thus preventing too many from fully contributing to our country's well-being. We call on leaders in higher education and our elected officials to take the necessary steps to ensure that we are investing in our people, all of them, by providing a path to higher education. But we also want to underscore that this was a narrow decision on just one aspect of the college admissions process. It would be both wrong and unsupportable to take this decision as a referendum on the need for diversity, equity, and inclusion overall. Let me be clear, we are not finished making this a truly equal society. We are not a colorblind country, no matter what the majority of the Supreme Court may say today. And affirmative action has been one of the most successful ways we have to actually get full inclusion and equality. So we are now more than ever determined to fight with every legal means available to ensure that communities of color, nearly 40% of the US population and the future of this country, have their fair shot at a college education and their American dream. Thank you.
Thank you very much, Janet. Really appreciate that. We'll go to Tom Sines now. Tom?
Thank you, Mark. This is Thomas Sines, President and General Counsel of MALDEF, the Mexican American Legal Defense and Educational Fund. I echo my colleagues in noting that today's decision is rife with contradiction. That demonstrates the impossibility of deriving a coherent social theory that denies the history and the continued devastating effects of racial discrimination on our nation and its students. Among those contradictions are the Chief Justice's recognition that a true merit system necessarily permits taking account of individual applicants' experiences of racial discrimination and the predominance of race in our society, while at the same time denying any means of acknowledging and incorporating the systemic society-wide effects of race and racial discrimination in our nation. The moral imperative after this decision is for higher education institutions nationwide to commit to do the deep and difficult work of identifying the admissions criteria that they use with a demonstrable discriminatory effect that cannot be justified as necessary to a merit system of admissions. That work requires not only looking at standardized tests, but the many other criteria that are infected by society's continued racial stereotyping and discrimination, primarily in academia, against Black and Brown students. Finally, the contradictions of this decision demonstrate that in fact there is nothing wrong with the admissions systems at Harvard and UNC that can coherently be identified by the right wing. That means, and I emphasize this, that every student, every Black student, every Latino student, every student of any race at Harvard, UNC, or any other selective higher education institution have every right and deserve to be exactly where they are. They all belong despite the tortured reasoning of today's majority decision. Thank you, Mark.
Hey, Tom, thank you very much for those remarks. And now we will go to Derek Johnson of the NAACP. Derek.
Good, thank you, Mark. Today's decision is an example of the Supreme Court failing America. 63% of Americans stated that they did not want the Supreme Court to tamper with affirmative action. In fact, because of diversity, this country has grown stronger. Unfortunately, this Supreme Court is trying to cast a reality that's more reflective of 1950 than the reality of a global economy. The NAACP will continue to partner with our legal partners that's on this call and support efforts because we must embrace diversity no matter what. Thank you, Mark, for organizing this call.
Thank you very much, Derek. And we'll go to Maya Wiley. Maya?
Good afternoon. I am Maya Wiley, the president and CEO of the Leadership Conference on Civil and Human Rights, and I could not possibly be more informative or on point than any of my colleagues on this Zoom. So I'm just going to be blunt. I find it interesting that a majority of our Supreme Court thinks that it's a problem to take race into account when we see 40% of banned books across this country banned because the main characters are people of color. I find it interesting to hear that we are somehow beyond race when we see at a University of North Carolina, a Nicole Hannah-Jones, a Pulitzer Prize winning journalist who tracked the history of racism in the United States from the founding of the country, who is challenged in her ability to get tenure because a wealthy person who gives a lot of money to UNC calls to complain about her viewpoints. I find it interesting to say that we're beyond race in this country, the need to look at it, when we know that 48% of white students admitted to Harvard between 2009 and 2014 either were legacies, meaning they were children of alums, or they were athletes, meaning many times they're in sports like fencing or squash, things that are not offered in the schools that our children are offered by, but we call that race neutral, despite the fact that is very much coded to the very history of race discrimination you have already heard described. So at a time when we see race violence increasing, hate crimes increasing in this country across all the communities from all the leaders you have heard on this call, and to know that race is still the top predictor of the majority of people who will suffer from that hate violence, I find it interesting to suddenly feel that we should not look at race. So what I will say in closing is this. This is a country where a majority of the people have already said we need unity over division. We need opportunity over exclusion, and we need democracy that means we all have a representation and a voice. And what this decision does is fly in the face of facts, fly in the face of human experience, and it flies in the face of the direction that a majority of this country wants, and that this call, these leaders, the organizational work represented here represents. Thank you.
Thank you very much, Maya, for those words. Siobhan Arline Bradley, bring us home.
Thank you, Mark, and to our colleagues on the line. I'm Siobhan Arline Bradley, the president and CEO of NCNW, the National Council of Negro Women. And NCNW, we stand today with our colleagues on today's rulings. As we consider the role of representation, the Supreme Court's first and only Black female justice, Ketanji Brown Jackson, has noted that gulf-sized race-based gaps with respect to health, wealth, and well-being of American citizens were created in the distant past. And NCNW believes today that this decision reinforces, widens, and perpetuates these very gaps by this court. And in her published dissent, she says it this way: given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmissions of inequality that now plague our country. NCNW could not agree more with our Supreme Court justice, and we see that the cruel irony in the fact that measures proven to help right the wrongs of the past are now being diminished by this very court. Our founder, Mary McLeod Bethune, believed deeply in the role of education, and this decision, it stands in the face of a road to ensure representation of students of color and the future leaders of our next generations. Their road is now being blocked. So our mission as an organization with our fellow colleagues is to advocate and empower women and families of African descent. And our role as civic-minded and engaged citizens could not be more important than today. So my colleagues say to you, we stand together. We're going to continue to do what we need to do in this moment, and that is to fight every attempt to turn back our many steps forward. NCNW is also calling on a diverse cross-section of industries, education, government, healthcare, corporations, to continue to double down on efforts to advance diversity, equity, and inclusion. As a collective, we stand united and will not be marginalized, will not be devalued, and we will continue to fight forward. Mark, and to my colleagues, thank you for the opportunity, and to those that are listening, know that we are united together, hand in hand, communities of color and leaders that are allies in this work, to ensure that we fight back until victory is won.
Siobhan, thank you for those words, and colleagues, thank you very much. Members of the media, we are going to take a few questions. In the interest of time, it's about 10 minutes to the hour. So let us open the line. Tess, are you going to moderate this?
Yes, sir. We have a question from Sarah Callis. How can this decision affect universities that do not currently consider race a factor in admissions?
Would Janae or Damon, do you want to take that? Janae, go ahead.
So that's a great question. One of the things that I wanted to make sure that we said today was not only is it still possible and not prohibited to discuss race in applications and to consider it as it informs someone's ability to overcome adversity or their inspiration in life or some qualities that intersect with their race. I want to be clear that universities, corporations, every entity in this country is still bound by anti-discrimination laws. They still have to comport with Title VII, which prohibits race discrimination in the workplace. They have to comport with Title VI, which prohibits the use of federal funds in any program that discriminates based on race. And so there are confines, there are legal mandates that require that our country continue to advance the principle of anti-discrimination. So if there is a university or college that presently does not have a program that considers those complexities of race, they should think about what the Supreme Court did say is possible and remains legally viable in this decision. And in fact, the mandate to create broader opportunities is that much stronger in light of this decision and how it has made it more challenging. It has not made it impossible, it's made it more challenging. And we challenge every entity to take up that challenge and do its part.
Thank you. Tess, next question.
In light of this decision, what advantage will this decision give or maintain with the admission of legacy students?
Damon, do you want to take that?
Sure. I'll jump in. Damon Hewitt, Lawyers Committee. So the decision doesn't immediately confer an advantage, but what I'm going to say to our friends in higher education is, if you are using legacy admissions, legacy preferences, and no longer using race-conscious holistic admissions, at least as far as the court will allow you to do, then you have a big problem. That, we believe, is a walking civil rights violation. As Janae has often said, having legacy preferences, especially without more, is the functional equivalent of a grandfather clause. It's like saying if your grandfather could go to this school during the days of Jim Crow, then you can go too. That is another form of racism that is structural and systemic. So those institutions better watch out, because you're going to get sued. As Janae also said, these institutions have an affirmative obligation under federal law. The obligation is not just to protect yourself from liability from those who may sue you for promoting diversity. You have an obligation if you have a hostile environment on campus or in the workplace, or if you don't do all that you can to promote opportunity. If you leave Black and brown folks stuck at the bottom or excluded, that is a potential civil rights violation. So as you're talking to your counsel, get your law right. Don't think this only goes one way.
Thank you, Damon. Next question, Tess.
Considering the decision, might race-based scholarships, recruitment by athletic departments, and/or faculty recruitment be impacted in any way? And how might HBCUs be positively impacted by this decision?
Who wants to take that? I think it involves how the decision is interpreted. So Janaea, Damon, or Tom, would you all have a perspective on this? Who wants to take this question?
I think this is another example of what this decision does and what it doesn't do. This case is squarely about two admissions policies at two specific schools, Harvard and UNC. And while we fully disagree that those admissions policies and practices are unlawful, the only thing we can extract from this particular opinion is that the court found that those two policies and practices were not consistent with the court's interpretation, a very legally unfounded one, but the court's interpretation of the Equal Protection Clause and Brown versus Board. That's it, full stop. It is cabined within the four squares of that analysis. And again, as many of my colleagues have said, will people be nervous? Will they be scared? Will they fear being targeted by these same extremist conservative organizations? Sure, we know that that is the case, that this is intended to have that very chilling effect. And we must resist that. We cannot capitulate when the court did not rule out those other possibilities. So no, scholarships are not affected. Recruitment efforts are not affected. This decision is about two specific admissions policies.
Right. And if I could add, Mark, I'm not sure if I heard correctly, but if there's anyone out there who has a notion that HBCUs discriminate, they are wrong. They are the most inclusive institutions in this country. And the demographics actually may surprise you, especially at the 6 HBCU law schools. As Mark knows well, one of the better known alumni of Southern University Law Center in my home state, our home state of Louisiana, was a former, now deceased, white Republican governor, right? That's an inclusive mission, right, for these institutions. So HBCUs are not discriminating. They are actually mission driven and opening the doors of opportunity more broadly than the PWI institutions.
Great point. That's an excellent point, Damon. Tess, next question.
From Will Sutton with the Times-Picayune Advocate, can higher education institutions consider personal and professional backgrounds, experiences, knowledge, and expertise without regard to race as they look at admissions? And is this specific only to the two institutions that were party to the lawsuit?
Well, Damon here, thank you for your question and your coverage here for New Orleans and Louisiana and nationwide. Look, schools can consider all of those things with regard to race, right? That's what Chief Justice Roberts wrote. And it's important to remind ourselves what he said, that nothing in today's opinion prohibits institutions from essentially inviting student applicants to talk about what we call their racialized experiences. That is your identity, your experience with race as a social construct, your experiences with racism, how you've navigated in society. So it's actually, I would say, with regard to race. But I'll stop with that. But I do think it's important to know that there's so much that is still permissible, and there's so much that's going to be confusing. We understand that.
And
but it's important. Yeah.
I want to offer this too. We've been aware, if you followed the president and the administration's expressions on the case, that the Department of Education and the Department of Justice are going to promulgate guidances that go to the institutions of higher education. So we await that. I think these questions go to more clarity around permissibility of steps that are to be taken. And I want to emphasize that there's a tendency we have to speculate and pontificate. And there will be many people in the court of public opinion who are going to misinterpret this decision. They're gonna take it to say what it doesn't say. And so one of the reasons why we're speaking forcefully, and in the case of Janae and Damon and John and his colleague, they were actually involved in the case. And as such, I think have a unique perspective and ability and standing to talk about what this decision is and what it isn't. And we want to emphasize that as much as we can with each and every one of you. So Tess, next question.
We have no other questions in the queue.
All right, so let me do this. Let me thank all of my colleagues for their time and patience today. And I want to thank those who litigated the case for their hard work on this case. And we shoulder on. We go forward, and each and every one of you for participating today. And we want to thank each and every one of you in the media for your time and attention today. And we will certainly be eager to watch and see what you write, what you broadcast, and what you say. And let me invite you to stay tuned and stay in touch, as this is not the last we will have to say about this case. So thank you very much. Have a good evening.